welcome everyone here today. For those of you who don't know me, my name is Bill Silverman. I'm a litigation shareholder here at Greenberg. I run our pro bono program. I also run our fellowship foundation. So basically my job is to make the firm a little less profitable. The challenge for pro bono in any big firm is to try to look beyond the individual case and to try to make a difference, to try to bring about change where change is necessary. And that's why we're here today. New York is one of only 2 states where all 16 and 17-year-olds are tried in criminal court, and we need to change that. A 16-year-old is not a miniature adult. We all know that, and now the law has to catch up. I urge all of you here and all of you who are watching this on the internet to get involved in our campaign. We can change this. We can get this done this year. We got more family court judges last year. We can get this done this year if we all work together and we all get behind this proposal. I want to thank all of you for being here, especially the judges and all of our other very distinguished guests. I want to thank our panelists. And now I want to turn this over to Dennis Hawkins of the Fund for Modern Courts.
Thank you, Bill. Good morning, everybody, and it's a pleasure to be here. I've told many of the panelists that this is going to be a very light moderator role because they have so much to say, and I know that you will have questions and answers. So other than saying, thank you to Bill, who has been a hero to those who care about family court in a variety of ways, making this his firm available to the More Family Court Judges campaign and coalition, and now for this, and underwriting a video that was produced for More Family Court Judges that put a face on the issue of family court. And we're here today to have the panel present information about how the system currently works and outline the issues and report on the proposed recommendation of the Commission on Youth, Public Safety, and Justice, and to discuss finally the statewide advocacy to change the laws in New York. And before I introduce the panelists, and you have bios, so I'm not going to go into detail, I just want to say that, from Modern Court's perspective, and I think from Jennifer's Citizens Committee perspective, who are actively involved in this this campaign, we spend a lot of time talking to ourselves, and that's what we're doing today. We're talking to ourselves, and we are educating ourselves. But as I think Jennifer will really underline, we have to talk to other people who are not on board and who do not understand. And I'll give the briefest of examples. Most mornings I walk with a fellow I used to work with in the district attorney's office, public information guy, 2 different district attorneys, reporter, worked for DOI in the same capacity. And when I brought this topic up that Modern Courts was involved in it before the Commission's report was issued, his immediate reaction is lock him up and throw away the key. And that's a progressive guy who knows law enforcement, and in minutes I said, hey, wait a minute, we're talking about kids who committed misdemeanors. We're talking about kids that I worked with pro bono who were diverted in a program called Project Redirect, who he knows because he's seen the kinds of things they wrote about their lives and gang membership. So it's my friend and people like my friend who we have to convince that this is not going to be some kind of get out of jail free card. We're talking about our kids, our children. So that's where I hope we go, and that's all I'm going to do in terms of that, because I know Jennifer has a lot to say specifically. So on our panel, we have 4 members of the Commission on Youth, Public Safety, and Justice. Jeremy Creeland, who's on my far right, who was the co-chair of the commission. He's also a board member of the Fund for Modern Courts. Sophia Elijah, co-chair of the Governor's Commission. Judge Marks, member of the commission and first deputy chief administrative judge. Joel Cooperman, also on the commission. and the CEO and President of Cases, and last but not least, Jennifer March, who is the Executive Director of the Citizens Committee for Children, and is the lead organization in this entire campaign. And we're going to try to stay within 10 minutes of the presentation so that we have enough time for questions and answers afterwards. And I think Jeremy and Elijah are going to kick off with discussion and a PowerPoint presentation. Thank you.
Thank you, Dennis. On behalf of the panel, I just want to thank Bill Silverman and Greenberg for hosting this, and I want to thank Jennifer and the Citizens Committee on Children for, and also the Fund for Modern Courts for co-sponsoring this. These kinds of gatherings are critical to not only to educate in a very complex area, but also to help mobilize folks to get the laws changed. So I'm grateful, and we're grateful for the opportunity to be here this morning. Tell me if you can't hear, but I'm assuming that the mic is working okay. So we have a PowerPoint which basically mirrors the PowerPoint that we used to present the recommendations to the governor in January, and we'll go through it. And I think what it tries to do is give some sense of the context and what our findings were and the recommendations, and then we can talk about where we go from here more during the question and answer period. So let me begin. So before we get into the recommendations, I want to place our work into context a bit. And one of the interesting things we found in our work is that New York State was really actually the first state in the nation to choose to place juveniles convicted of a crime, juvenile offense or crime, in separate facilities from adults. And in 1824, the Quakers created the House of Refuge in New York City as a place to put juvenile offenders. And in 1846, the New York State Legislature launched the nation's first explicit policy of separately housing juvenile offenders by designating the House of Refuge on Randall's Island, which is shown here, as the exclusive place for juveniles in the city to be sent. So in many ways, the effort that we're focused on today and with the Commission is trying to restore New York State's leadership in juvenile justice and bring it back full circle to where we began in some ways. Now, I'm not suggesting the House of Refuge was a cup of tea. I mean, it was not. I'm sure there are many reformers would have their qualms about it, but it's all relative. I'm sure the prisons were not such a great place either. So, of course, as everyone I think in this audience knows, New York is at this point an outlier. By 1927, most other states had already raised their age of criminal responsibility. 28 states to age 18, and most of the rest to 17. New York was still at 16. That's almost 90 years ago. So now New York is only one of only 2 states that treats 16 and 17-year-olds as adults for all purposes in the criminal justice system. And that was the reason why the governor appointed the commission, and our mandate in large part was to develop a plan to raise the age of criminal responsibility in a thoughtful, sensible way that could garner broad support and change that once and for all. So in April, the governor appointed a 16-member commission, and thanks in large part to the support of the Vera Institute for Justice and the foundations that generously supported the effort, the commission's work was about as deep and extensive as any commission I've seen. In the space of less than 7 months, we did 14 focus groups with over 200 participants around the state, over 40 interviews with stakeholders and national experts. We did an incredibly intensive data analysis of the current system and how it processes cases with the help of the state, with DCJS and OCFS. We did public hearings with 22 witnesses. We brought in folks from Illinois and Connecticut to speak to the commission about their raise the age efforts. We visited docks, prisons, OCFS juvenile facilities, Rikers, 2 juvenile detention facilities, and a residential treatment facility in New York City for young people with mental illness. So the commission, was really steeped in this how the current system works and how other states have done it for that period of 7 months. And I can tell you, I work at a law firm and we track our time, as Bill does, by the in 15-minute increments. So I can tell you exactly how many hours I spent, and it was enormous.
We use a 6-minute increment.
6 minutes, yeah. Well, we use 15, but still way too many hours. So I want to turn it over to Sophia, and she's going to talk a little bit about some of our findings. You have to actually get you the right slide.
Thank you, Jeremy, and good morning, everyone. Before I start on the findings, I just want to share with you, I want to put a face on what we're talking about. For those of you, and I know many of you have already worked for a long time in this arena, but just yesterday and the day before, I went with my organization, the Correctional Association of New York, to visit the Southport facility. And for those of you who don't know, Southport is like a maxi-max prison in New York State. It's a SHU. Everybody is locked up 23 hours a day. And for many people, they're locked up 24 hours a day. And we went from cell to cell, interviewing each and every person there to get a sense of what their experience is and what the conditions are under which they are held every day. And as I was going from cell to cell, I was struck by how many very young faces I saw. And I came across one young man who clearly, he seemed like he was shell-shocked. That's the best way I can describe him. And he looked young, and I asked him, I said, "How old are you?" And he said, "Well, I'm 26 years old." So I said, "Well, how old were you when you came to prison?" He said he was 16 when he came. And then I asked him, "How many of those 10 years did you spend in solitary confinement?" And he said 8.5. And that was really chilling to me. And it was one of the things that I took away from that experience as I knew I was coming here today. I thought it was really important for me to put that really human face on what we have done to our children for so many years and why it's so important for us to turn that tide around quickly and permanently so that I never meet another young person in prison who's had that experience. So let me turn to our findings. As you see from the slide, today there are 800 people in local jails and state prisons who are under 18 years of age, and they suffer under the most horrific conditions and are far more likely to commit suicide than any other group or are incarcerated. We looked at many things, as Jeremy told you. First, and perhaps the most well-known, is the impact of detaining 16 and 17-year-olds in adult facilities before trial and imprisoning them in adult prisons after they are sentenced. Nationally and here in New York State, the research has shown two key facts. The first is that youth who are 16 and 17 often suffer horribly inside adult facilities. And second, we know now that the recent brain research has shown that teenagers, anyone here raised a teenager? This isn't going to come as any news to you then. That teenagers' brains develop slower. Well, not slower. Eventually they catch up. And there's some debate as to whether or not that's in their 30s, but we're focusing on the 16 and 17-year-olds. But that the part of their brains that control impulse is the frontal lobe, and that part of the brain develops last. And that is in large measure, I know parents, you will feel redeemed, that's in large measure the reason that they do the things that drive us absolutely nuts, and why we find ourselves here today. But what is less known is that these brains are the most likely to be prone to rehabilitation if you provide these young people with the necessary supports and services that they need. And that is what we focused on with the commission. We know that youth of color are much more disproportionately affected by the criminal justice system than any other group. Our research made that clear to us. The current system, the impact that the current system has on youth of color and on their community is far more harsh than any other community. And it's also important that we not ignore the fact that in upstate rural areas, many, many poor white youth are also disproportionately impacted by the criminal justice system. But for the injustices that exist in the system, they are clearly more harshly felt in communities of color. Our youth face lifelong consequences just for one mistake in their adolescence, and that is something that we need to change. We found, for instance, in New York State, that we lag behind severely in giving young people a second chance by allowing certain crimes committed as a teenager to be sealed or expunged later if the person stays out of trouble, and that's an area that we focused on. So our current law now does allow courts to give young people under 16 to have youthful offender treatment, but not enough young people. In fact, let me say that over. Now our current law does allow courts to give young people who are under 17 a youthful offender adjudication instead of a criminal conviction, but that does not affect any young people older than that. And we found through our research that we need to broaden the coverage of youthful offender treatment. There are limitations in our current youthful offender law, which I will discuss, but it does ensure that 75% of 16 and 17-year-olds convicted in criminal court have only a confidential record. There are still about 1,600 minors a year who obtain criminal records, and unlike most states, New York has no mechanism by which to have their criminal records sealed or expunged, even if they committed them when they were very young, and the crime was not serious, and they have lived a crime-free life for a substantial amount of time. Criminal records present lifelong barriers to education, access, employment, and housing, and therefore contribute to the continuing cycle of poverty that we see in so many communities. So when we talk about giving kids a second chance, there's a major deficiency in our existing New York laws. We looked at cost-effective, evidence-based interventions for youth and found that they are not widely available in New York State. In order for a probation department to divert a case so it doesn't turn into a court case, or for a judge to consider alternatives to incarceration in their sentencing of a youth to an out-of-home placement, the county has to have solid options for services for youth and their families. We know now what works: intensive family therapy and mentoring and supportive services. We conducted a survey, the first of its kind actually, and of all of our county probation departments throughout the state, so that we could learn what services they had available to them to offer as an alternative to a court case and detention. And here's what we found. 5 counties had 0 evidence-based services for youth, nothing at all. 24 counties had only 1 or 2 evidence-based services available for young people. And only 5 counties had more than 5 evidence-based interventions available for youth. So no wonder that we have such high recidivism rates for this population. The key is that these services are far cheaper and more effective in reducing recidivism than allowing the case to wind its way through court and have the youth detained and ultimately placed. Yet New York State does not have the services it needs in many counties, and this has a ripple effect: more detention, more cases, more prison, more cost, and ultimately more crime. We found that too many low-level cases against young people result in deep-end involvement in the criminal justice system, and our recommendations focused on trying to reverse that trend. We found that even though the number of youth detained or incarcerated has declined significantly as a result of the reforms that we have already implemented, more can be done and must be done so that we can get very low-level offenders into alternatives to detention or of incarceration that work well. About 1,700 16 and 17-year-olds annually receive sentences with some jail time for misdemeanors that do not involve violence. More than 250 young people under 16 were sent to placement last year for misdemeanor offenses. And those are the youth that are actually accused of a crime. In addition, there are juveniles under 16 who are placed out of their homes for what are known as status offenses because they are incorrigible, otherwise known as teenagers, or their parents simply can't get them to attend school. These are what we call persons in need of supervision, And anyone who's worked in court knows when you hear the word pins, you run. New York State spends over $100 million every year to place those children, often in places that are not much better than juvenile detention centers. Meanwhile, other states have shifted their focus and their resources and focused them such that they provide better services for those young people and keep them in their homes. Those services have reduced recidivism more, cut costs, and reduced the need for placement and provided better outcomes for our young people. Our next finding was that not only do we lag behind 48 other states, this policy is actually undermining our public safety. Our current system may be creating more crime than less. And I know that sounds pretty shocking, but it won't be the first time that we did things backwards. Our research has shown that youth processed as adults have a 26% higher likelihood of reoffending and reincarceration than youth processed as juveniles. In other words, treating children like children in our system has been shown to reduce crime. So these reforms will make us safer and will ensure better outcomes for our children. I'm now going to turn the mic back over to Jeremy, who will tell you what our recommendations are.
So Sophia went through some of the key problems that we found, that we identified, and I'm going to talk a little bit about our recommendations. And this is really a 30,000-foot overview. If you really have the time and the inclination, you can read through the 200-page report, and let me know if you get through it. First and foremost, we recommend changing the law to raise the age of criminal responsibility to 18. That's no surprise. That was our core part of our mission. And we talked extensively to Connecticut and Illinois about how they raised their age of criminal responsibility. And the key message we heard from them is that we should phase this change in so that you can build the systems and the services you need to make the reform a success. They both can, and this was a pretty fascinating and surprising finding. Both Connecticut and Illinois expected a massive influx of 16 and 17-year-olds into their juvenile system when they raised the age, and they expected to have to build large numbers of new juvenile facilities and new courts. But in the end, the influx didn't come, and it didn't come for one major reason. Both states phased the change in. They planned very well and invested upfront in some of the key diversion services and other systems that reduced the need for more facilities and more courts. So our recommendation, the bottom line is our recommendation is that January 1st, 2017, the age of criminal responsibility should be raised to 17. January 1st, 2018, it should be raised to 18. And in the interim period, there should be an emphasis and investment on building the key services. Second, the Commission recommended that no person under 18 be detained or imprisoned in an adult jail or prison. And the report details how to get this done. In particular, the Commission concluded that it's a tremendous opportunity, in fact, for New York State to lead the nation in developing new secure juvenile facilities to the extent they're needed around the state that use best practices for rehabilitation and education for these youth. And as many of you know, I know in this room, Missouri is the gold standard here. And we believe, based on our analysis, that a network of small facilities, under 25 beds, should be created with intensive programming and support, staff teams that are focused on ensuring the youth get the help that they need for a successful reentry. Less bureaucracy and more direct staff counselors is a critical part of it. It turns out that those facilities are actually much cheaper, and they're also much better at reducing recidivism than our current model. And in addition, we recommended to help reduce detention and placement of youth who do not pose any risk to public safety. We recommended a statute that prohibits detention and placement for low-risk youth charged with nonviolent misdemeanors, except where there's a specific imminent threat to public safety. Other states have done it, and New York should do it too. It's not it's not a reform that is confined to blue states. Texas and other states have done this, and it's a key part of shifting resources away from very costly and ineffective detention to much more effective and much less costly services and interventions. Next, and diversion is an area we spend a lot of time on in the report, and I won't go into great detail here because I don't want everyone to fall asleep. But the Commission recommends removing a whole series of barriers to successful diversion or adjustment of appropriate cases so that they don't end up in court at all. And part of it, the front end of it, which is already, Governor Cuomo has already started over the last few years, is to focus on putting in place an objective risk assessment tool across the state to determine effectively which cases are suitable for diversion and not rely just on eyeballing a case or other factors, and then setting up the rules properly so that a larger universe of cases can be considered for diversion and adjustment, and that there's a requirement that such cases are, there's an attempt to divert them. You're not going to be successful in every case, but there should be an attempt in all those cases. So it's a matter of changing the rules and also creating effective diversion services across the state. Now, next we get to the court system, and Judge Marks, will have a more nuanced discussion of this, but I will give you kind of the overview. It's complicated, our recommendations, but part of that is because the existing court system is very complicated. Part of that is because our recommendations were unanimous in the commission. That was a key goal of ours. I think we made clear from the beginning to the commission that our recommendations would not be worth the paper they were printed on if they were not unanimous, and that our goal was to have not a report that sat on the shelf, but a report that would be translated immediately into a bill, and which it has been, and would ultimately be passed. So, our recommendations reflect a balanced approach and a lot of some would say compromises, others would say carefully thought out measures that can garner broad support. I like the latter characterization. So let me take a stab at it. First, there are a couple things that we found that are critical to remember as background. Every single state, all 50 states, have carve-outs so that the most serious violent offenses committed by youth are handled in the first instance in adult criminal courts. Every single state. And that's an important fact for a whole host of reasons. The other fact is that in Connecticut, Illinois, and other states that have raised the age, not a single one of them included in their reforms dealing with the most critical violent offenses. In other words, all those offenses continued to go to criminal court. So our reforms went far deeper by addressing violent offenses than reform efforts in other states. So when folks talk about how we should have gone farther, you have to keep that context in mind. A lot of reform efforts just said we're not going to touch that because politically there's no chance we're going to get that. So here's what we recommend. First, all misdemeanors and nonviolent felonies for 16 and 17-year-olds would be handled in family court, where juvenile delinquency cases are handled now. That means 9 out of 10 cases against 16 and 17-year-olds would go to family court, 90%. Second, serious crimes of violence, violent felony offenses, and certain other major offenses committed by 16 and 17-year-olds would originate in criminal court, but not in the current courts. We recommend creating new youth parts around the state to handle the 16 and 17-year-old cases, and with specially trained judges, experts in the ways and needs of young people and their families. It's an idea recommended by Judge Corriero in his book, and who presided over a youth part in Manhattan and many others. It's a proven concept in New York and elsewhere. In addition, we recommended that those judges would be clothed by statute with concurrent Family Court Act and criminal court jurisdiction. So in effect, they would be family court judges and criminal court judges in one. As they are now, appropriate cases would continue to be removed to family court. So And one thing I think it's important to recognize that people don't realize, some people talk about how family court is, can't handle the more serious violent cases. Under our current system, a third of juvenile offender cases, which are the most serious crimes that go to criminal court for 16 and 17-year-olds, are currently transferred to family court. So family court has shown, that it can handle these very serious cases. So appropriate cases would be removed to family court as they are now, but for violent felony offenses and for the robbery 2 charges, which are juvenile offender, which fall into the juvenile offender law, there would be a new rebuttable presumption in favor of removal to family court. So they would start in criminal court, but there'd be a rebuttable presumption in favor of removal for violent felony offenses and the Rob 2 JO charges. DAs who would retain control of these cases regardless of the court could rebut that presumption if the defendant played a primary role in the crime or other aggravating circumstances are present. The judge could decide then to remove the case to family court, actually send it across the street or wherever family court is, or to keep the case in the youth part as a criminal case, or keep the case in the youth part and exercise his or her family court jurisdiction and handle that defendant's case under the Family Court Act. So there's a series, depending on the particular case, a series of options that can be used to address the particular case. And our feeling was basically this was the best of both worlds. You get the benefit of family court, but also in appropriate cases, the flexibility for judges and DAs to keep defendants together in one courtroom and keep them in criminal court where appropriate, rather than splitting the cases in every, between courts in every situation. And in addition, it's important to emphasize that even those cases that remain in criminal court that aren't transferred would receive juvenile probation interventions and would never be detained or incarcerated in adult facilities. So basically, every single 16 to 17-year-old, no matter where they end up in the court system, would be handled very differently than they are now. And that was our operating principle, that no matter where they end up, they should be treated differently. Next, we focused on some of the barriers to success that Sophia outlined. We recommended a series of reforms to give youth a true second chance. First, we recommended expanding eligibility for the youthful offender status from 18 to 20. Second, we recommend allowing those who committed nonviolent offenses at age 18 to 21 to get their records conditionally sealed for civil purposes if they remain conviction-free for at least 5 years after release from prison or 2 years for a misdemeanor. And then on the other side of the equation, we heard from many people in law enforcement that they have significant trouble in identifying that very small number of the most persistent violent offenders. To address that and improve public safety, we recommended that if someone receives a youthful offender adjudication for a violent felony, and only for a violent felony, but then later commits another violent felony offense, then law enforcement and the court should be able to use that YO as a predicate offense for charging and sentencing purposes only. Together, these reforms will place New York basically at the front of the pack in reducing the collateral consequences for young people of receiving a criminal record, while also at the same time protecting public safety. Finally, to make the entire set of reforms work, other states have shown that we must invest upfront in the kind of intensive interventions that have been proven to reduce recidivism and reduce the need for detention and incarceration. We recommend establishing, we took a page from Connecticut and their reforms. We recommend establishing family support centers around the state with the types of services shown here and others, the treatment foster care, the family therapy, family assistance, mentoring. These are the kinds of services that are proving very effective in reducing recidivism, and they end up being a lot cheaper than putting a kid in detention. There are a whole series of other reforms, recommendations that are in the report that we talked about. One of them, for example, is weekend arraignment, which happens in New York City, but upstate in a lot of places, weekend arraignment for juveniles does not occur, so kids spend the weekend in jail, which can be eliminated. It's expensive and it's not good for the kids. So there are a whole other series of reforms that address that. So if all these reforms were passed and implemented, what can we expect to happen? Our research suggested that these proposals would reduce crimes between 1,500 and 2,400 personal crimes every 5 years, and if you look at Connecticut and Illinois, both arrests and recidivism declined dramatically after they raised the age among 16 and 17-year-olds. It's just an amazing finding. I mean, it's just incredible that not only did they not see the influx into the system of 16 and 17-year-olds into the juvenile system, but the rates of crime in that population that were already declining kept on declining, and increased in the rate of decline in many cases. So it is a pretty remarkable, it's so rare you see that kind of policy, that kind of counterintuitive policy implication. So I'm done. I just want to say one other thing, which is about, in terms of status. These reforms, we presented them in mid-January to the governor, and a week later they were put into a series of budget bills, Article 7 bills, as part of his executive budget. And there are 30-day amendments which are going to tweak some of those proposals and refine them even more, which are coming out, I think, next week. And if all goes well, they'll be passed in the budget April 1st if we get a non-time budget this year. And then it'll be a matter of putting in place the services. And he also importantly said in the State of the State, he added to this as a kind of a down payment on the raise the age reforms, that he wanted the legislature to change the law so that any 16, 17-year-old who was sentenced as of January 1st, 2016 on should go to a juvenile facility, OCFS facility, rather than a DOCS prison, which would accelerate that piece of this reform. And we worked a lot with the state to try to figure out what that would look like and what the rate would be. And so he wants to start this as quickly as possible. Okay, thank you.
Okay. You finished, Sophia?
Yeah.
Okay, I want to just let everybody know that we'll have a question and answer period after everybody has presented so that everything will come up. But as a moderator, I'm just going to take this opportunity to thank all the members, but Jeremy and Sophia, again, for the development of this report. And a couple of things, when Jeremy talks about the solution for the disposition of the cases is complex because we have a complex system. Some of you may know that Modern Courts has been advocating for years to simplify the court system and to unify it, and we have not achieved that goal yet, but if it were a simpler system, probably the recommendations could be simpler rather than all these moving parts. I think the other thing that jumps out at me is 30 years ago when I was starting out as a prosecutor, a very wise older prosecutor gave a lecture to new prosecutors about the criminal justice system is not a system. It's all individual parts with different goals and competing interests. Over the 30 years, I've developed a more nuanced kind of approach to that. And one of the things I think the Commission has to be congratulated for and recognize is that they treated the criminal justice system as if it were a system right from the start, so that all of the analysis and recommendations anticipate what has to happen in different parts of the system. And Judge Marks will be talking primarily about the impact on the courts. We know that Cy Vance and Janet DiFiore, DAs, were on the panel. They gave consideration to the impact on the DA's offices. Presenting authorities like the Corporation Counsel have to be taken. Prison, probation, and you have to be taken. I think from my reading of the report, all of that was considered. And 3 years ago, in June of 2011, I first met Sophia when she participated in a panel that Denise Kronstadt, our deputy executive director, had in Albany on Raise the Age, the issue of Raise the Age. And what really jumped out, in addition to when I watched Sophia's statement yesterday, she always puts a face on things. I think that's what we have to do. The numbers is abstract, all nice, but who are we talking about? What kids does this impact? So thank you, Sophia, for bringing that up. But the other thing is that an upstate DA was part of our panel 3 years ago. 3 things that she said that this commission has, I think, accomplished. Number one, let's have a serious study. research, academic, look at what other people are doing. That has been accomplished. She also said that from her point of view, the phase-in, like Connecticut, over 2 years, that has been accomplished. And last but not least, I didn't realize this because I don't remember it, about the YO status being used for persistent offenders. That was a big point that she had, that they're disadvantaged and not DAs in not being able to do it. So, I think that this report addresses so many of the concerns in so many parts of the criminal justice system that the commission and you and the governor are to be congratulated for that. Moving on to Judge Marks, who has the incredibly difficult task of making this work in the court system with the resources that are already strained. But Judge Marks has always been here for our family court efforts, attended many meetings of the more family court judges and kept us informed, and indeed had a conversation with Denise and I about hoping that modern courts would get involved in the raise the age issue, and here we are again, Judge. Thank you.
Okay, thank you, Dennis. And I just want to second what Dennis said about the, truly superb work that this commission did. Not just, you look at the report, the magnitude of the work that went into that report is obvious, but it's what Jeremy said. This was a unanimous report. The recommendations were signed off by everyone, and this was a commission, not just advocates. It was, there were a couple DAs on the commission, a police commissioner, probation. So all the kind of various interested parties, usual suspects were involved with this. And the commission, the recommendations were all unanimous, and I just want to commend the co-chairs for their leadership on that, because that was not obvious from the beginning that there would be unanimous recommendations. So I want to just talk about, and try not to be repetitive, but just talk in a little more detail about the important provisions in this bill that involve the court process, and in particular the interplay between the family court and the criminal courts under this proposal. So, and I also want to talk just very briefly about the chief judge's proposal, because to some extent this is, I think, an evolution from the chief judge's proposal, and a very positive evolution from that proposal. But I think, as you know, the court system has been very involved in the effort to raise the age of criminal responsibility in New York. The chief judge, in fact, offered a legislative proposal 3 years ago, and that proposal differs in many respects from this proposal, from the commission's recommendations, but there are a lot of similarities, and as I said, I think that to some extent this proposal is built on the proposal that the chief judge offered. And just very briefly, in a nutshell, the chief judge's proposal would have created a new youth division in the superior courts of the state, and misdemeanors and nonviolent felonies involving 16 and 17-year-olds would have gone to that youth division, and the youth division would have, it's kind of a hybrid approach, would have combined procedures from the Family Court Act and procedures from the criminal procedure law in adjudicating those cases. This proposal, as Jeremy explained, and I don't want to be repetitive, but this proposal would give exclusive jurisdiction to the family court for misdemeanors and nonviolent felonies in cases involving 16 and 17-year-olds, nonviolent felonies as that's defined currently in the penal law. And for the remainder of the cases, Jeremy noted that's, I think it's 85 to 90% of the cases are the misdemeanors and the nonviolent felonies. I think there are also two less than misdemeanor grade offenses that would be included in that as well. But that's 85 to 90% of cases involving 16 and 17-year-olds. Those cases would go to family court. Family court would have exclusive jurisdiction of those cases. For the remainder of the cases, which are the most serious cases, the juvenile offender cases, which are the most serious of the charges, And the violent felony offenses that are not juvenile offender offenses, those cases would go at least initially to a new youth part, newly created youth part that would be in the Superior Court in each county of the state. And that, as was noted, those parts would be presided over by specially trained judges. And there would be a presumption of removal for the violent felony offenses and the juvenile offender offense of robbery in the second degree. There'd be a presumption of removal of those cases to the family court, and that presumption could only be rebutted by the prosecutor by showing that the youth was a primary participant in the alleged crime, or that there was some aggravating factor. For example, if the youth had used a weapon in the commission of the crime. So most of those cases, the violent felonies and the one juvenile offender case, although initially starting in criminal court, would be removed to family court. The juvenile offender cases, a third of those, I believe, are now removed for the under age 16 population. But they could as well be removed to family court under the existing standard for removal, which is interest of justice, based on the judge's review of statutorily enumerated factors. As Jeremy mentioned, if the judge in the youth part determined that the case should be removed, the judge would have the discretion to retain the case and adjudicate it in the youth part, but adjudicate it as a juvenile delinquency proceeding under the Family Court Act. So that would be another option for these cases. And for the remainder of the cases, they would be prosecuted, which would be a very, very small percentage of overall cases. They would be prosecuted as criminal cases, but the defendants in those cases would have special advantages not available now. There'd be early assessment by probation and early pretrial interventions, programs, and services where that would be appropriate. There'd be reduced sentencing if a conviction resulted for many of the defendants. There would be, if there was confinement in any of these cases, it would be not in adult facilities, but would be in youth facilities. There'd be, as was mentioned, expanded opportunities for youthful offender adjudication, and there'd also be a sealing of court records and a criminal conviction option. So there are obviously some significant differences between the bill that the Chief Judge proposed several years ago and this proposal. But the court system fully supports this proposal, the new proposal, the Commission's proposal, the Governor's proposal. And that's because a lot has changed over the last several years. For example, arrests of 16 and 17-year-olds have plummeted in recent years, I think, and continue to drop as we speak. I think there are, over the last 5-6 years, there are roughly 40%, maybe more than 40% fewer arrests of 16 and 17-year-olds than there were. And the result of that is that, and this is based on analysis that Vera did for the Commission, which I think may in fact have been very conservative analysis, but Vera concluded that once this proposal was fully implemented and taking into account the significant number of cases that would be adjusted or diverted out under this model, that statewide there would only be approximately 6,800 cases, new cases for the family court. And I would note that that's barely more than 1%, 6,800 cases, new cases in family court would be barely more than 1% of total family court filings over the course of a year. So it's not a lot of cases. Secondly, as we all know, and thanks to the good work of many of the people in this room, we have more family court judges, 20 new family court judgeships this year, 5 more next year in 2016. So family court is much better able to absorb additional cases, and I know, I hope Edwina Richardson-Mendelson, who supervises the New York City Family Court, I don't see you cringing when I say that. But there's no question that we could absolutely absorb that number of cases. We will make that work, because remember, if there would be more family court cases, but there would be fewer criminal court cases, so we could move resources around, non-judicial resources, court staff if need be, but it would be a great problem to have if, if family court had to absorb 6,800 additional cases. So I think additionally, the reason why things have changed is really because of the first two factors. Family court judges as a group, and there may be a few exceptions to this, so I haven't talked to a family court judge who's suggested otherwise, but family court judges as a group support putting these cases in the family court. And that wasn't necessarily true several years ago, but that's true now. So, so the court system fully supports this proposal. It makes all the sense in the world. Family court is the right court to handle these cases, or most of these cases at least. It's a court that knows how to handle these cases. It's a court that has a structure already in place with links to programs and services that you need to achieve successful outcomes in these cases. It's the right thing to do to put these cases, or at least most of these cases, in the family court. So again, this is, I think, an excellent proposal, an outstanding proposal. Is it perfect? No, it's not perfect. Nothing is ever perfect. There are clearly compromises built into this proposal, although I like Jeremy's characterization. But it's the right thing to do, and it's a proposal that now I think we all have to rally around.
Thank you, Judge. And we're now going to go to Joel Cooperman, who, as I said, was also a member of the commission, and perhaps he can tell us a little bit about, the kinds of programs and initiatives that you anticipate will be needed to make this Raise the Age campaign succeed based on the experience of your organization.
So good morning. Very happy to be here, and I was very happy to be a member of the commission. It was, as we've all acknowledged, was a remarkable piece of work. Jeremy made reference to the length of the report. I'd point out there were 584 footnotes in the report, so there's some serious reading here, and it's a very serious document that I think will be a document that lives, and I think that the research and that was done in the report was really quite well done. I was particularly pleased in the report that there was some talk about the brain science, and that was referred to by Sophia. Both, for those of us who have kids, we know the brain science, but also that there is some important neurologists and psychiatrists and others who are looking at these issues, and we talked to some of them, and I think that it's important that we keep moving that conversation forward. I think that is a part of this report that reaches beyond the report and reaches beyond juvenile justice, and every time we talk about that and we mention that, whether it's in the context of the justice system or the education system, as schools think about what they're doing, every time we can move that forward to recognize and understand that 16, 17, 18, 19, 20, I don't know what the top number here is, that these are not, that these are children, and their brains develop in different ways, and so that's incredibly important. And so I was thrilled that was not only in the report, but at the front of the report, and lays the foundation for much of the work as we think about young people across our society, not just in the justice system. So a couple things that I would observe and comment about it is someone who is a practitioner in all this is, so my organization has been running programs for youth in the adult court for many, many, many years. We're actually a spin-off from Vera that started in the 1960s. We've been running these programs, and there's always been something odd about the way programs are constructed in New York for young people who are at liberty, right? And then eventually will come into our programs, they're essentially unsupervised, right? They're charged, they're arraigned, it goes through the system, and then, you know, the case is just hanging out there while judges and lawyers and prosecutors and everybody sort of does their thing, and 2 to 4 months later you come before the judge, the young person takes a plea and he's told to go to cases. Well, 2 to 4 months have been passed. It seems to have passed. And it seems to me that there ought to be an opportunity there. And because of the way the system is structured, pre-pleas are not something that are commonly done. So now this would change that, right? So here's this opportunity to get from the get-go young people involved in services in the community right at the point of arraignment. This is a good thing. This is a very good thing, and this is something that I think will advantage the young people who are going to get the benefits of these services. There'll be risk and needs assessments, there'll be evidence-based programs, there'll be a lot of things, but the important thing is moving that forward. This happened in the family court a few years ago, at least in the city of New York, and it's proven to be very, very effective. It not only gets people involved in services, but it demonstrates to the court that with services, young people can succeed in the community, and that's what we want to show. So I think it serves a diversionary purpose as well. So I was very pleased to have that part of the report. For the young people moving to family court, one thing that they will have available to them, and I love sort of the notion of this, is these sort of notion of off-ramps. Right? You can just sort of imagine that, right? So adjustment, as it's referred to by the Department of Probation, will now be available to lots more young people than was before. This is terrific. There are proposals out there, and there's actually practice out there now where young people's cases, they go through misdemeanor cases, and at the end of the day, the case is sealed. Better not, let's just skip that part of the process. Let's just adjust these cases. Let's go on this off-ramp, and let's provide the young person services, and let's skip the ACD or conditional discharge or whatever other outcome. We don't need to do that. Let's just get it out of the system. The YO provisions for young people that we serve, many of them are YO eligible. We have had terrible experiences of young people who did not get the YO. This is, I was going to say this was a game changer. Actually, this is a life changer. This is totally a life changer for people who are involved in the justice system, who commit that one crime that is just, they have to carry with them for the rest of their lives. And you know, if we were all sort of forced to deal with the stupidest thing we did as a 17, 18, 19-year-old, we potentially would all be in some kind of trouble. For these young people, this is a huge deal, and I can't underestimate the importance of this. Finally, for practice, sealing of records is going to be the opportunity to have this, to sort of start what I would hope will be a conversation in New York and important first steps about sealing of records. We don't do this so much in New York. Let's do this more, and let's do this not only for young people, let's do this for older people, people who've committed crimes, you know, 15, 20 years have passed. Really, let's put that behind. You know, we all put things behind us, and let's let people who are involved in the justice system put some things behind them as well, and not have to carry this with them for their whole lives. So there's lots of important things here that will affect practice, that will affect programs like cases and the other programs that work in this system. We will adjust to that. We will create new programs, and it's what we do. It's what we do all the time. I see my colleague from CCI shaking her head. It's what we do for a living, is we create new programs and respond to the situations that are in front of us. And so this is an absolutely terrific opportunity to do that, and we look forward, and we hope that the legislature will adopt these things. Jennifer will make sure that happens. And sure.
Strength in
sure.
numbers.
Yeah. And we look forward to sort of working in this new and better system.
Thank you, Joel. And last but not least, now that we know how the reforms and the recommendations work. And we have started to develop our arguments and our ways of talking to people outside of this room, legislators and others. We are ready to begin advocating, and the lead organization in this campaign to raise the age is the Citizens Committee for Children. And Jennifer March will tell us some of the ways in which we might influence legislators and opinion makers and others to make this happen. And I was interested to hear that Jeremy thinks that we should have this done by April 1st, so that you only have about 6 weeks of work left. And we're ready to go. Thank you.
Great. Which microphone do you want me to use?
Sure.
So, because I think everyone wants to quickly get to Q&A, I'm going to talk just a little bit about the Raise the Age New York campaign, how we got here, where we're going, and what we need all of you to do. So the campaign, as many of you know, kicked off in July of 2013, and the premise really was to build a groundswell of support for raising the age of criminal responsibility in New York. And I can't stress enough that there's real strength in numbers. So we co-chair the campaign with CDF New York, but there are 100 organizational members of the campaign, and 12 of whom function as a steering committee role, many of them in the room. Obviously, Center for Community Alternatives, the Committee for Modern Courts, the Correctional Association of New York, Families Together New York, the Federation of Protestant Welfare Agencies, the NAACP, Schuyler Center for Analysis and Advocacy, the Children's Agenda, Westchester's Children's Association, and Youth Represent. What we did basically, we looked at our toolkit of effective advocacy opportunities, and our job really was over the last year and a half to take content, the brain science, what's happening in other states, our knowledge of outcomes that are both positive and negative for youth, and to actually try to get that information into the media on a regular basis, upstate and down. We're fortunate to have a contract with Berlin Rosen, professional PR firm, that actually helped us do that. And then we actually overlaid our media work with effective government relations. So meeting with state agency staff, the governor's staff, legislators in the Senate and Assembly, spearheaded by my staff, Stephanie Gundel, and then supplemented with on-the-ground lobbying support through Malkin and Ross. And then we focused on mobilizing people at the local level. It's important to have community members invested in reform that impacts young people living in Long Island, Westchester, upstate New York, and elsewhere around the state. What's happened is basically the creation of a diverse coalition of faith leaders, unions, child advocates, law enforcement, conservative voices, direct service providers like Joel, and internal champions. So it basically created the internal and external pressure needed to make the idea of Raise the Age New York one that had to be addressed. And so essentially allowed the governor, really provided the governor the backing he needed to create the commission last fiscal year. And I have to say that, the commission members, it's really nothing short of miraculous in my view, the intense level of work, research that they've done in such a short period of time to produce a really profoundly pragmatic, doable, and also aspirational package of reforms. So what do we do now? We have to draw on those same tools, media, government relations, and grassroots mobilizing, to make sure that the information in the commission report, the budget bills, actually gets out to the general public. We need the general public to understand that this is good for young people and smart on crime. We need legislators in the Senate and Assembly to feel comfortable that this is the right way to go. And so I have a whole list of things that I expect you to do. So as we continue to engage people in op-eds and editorials and getting news out there that humanizes the story and has a diverse group of people weighing in positively publicly, we expect you to also, as citizens of the state of New York, to raise your voice. So there's super easy things you can do, and there's a multiplier effect. We expect you to tell your friends and colleagues to do it too. The first thing, go online to www.cccnewyork.org/RageTheAgeNewYork. There's a letter there. You fill it out, it goes to the governor, the leadership of the Senate and Assembly, and your local representative, and you can send it to 10 friends. I can tell you this is incredibly effective. As we move towards the creation of the commission, I think in a 2-week period, we had 75,000 letters jammed in legislators' emails. That's important. Super easy thing to do. The other thing we need you to do is use social media. I look around the room, there's varying ages in the room. You need to tweet, you need to post on Facebook, you need to engage the legislators. They all have tweeting handles, which we've left for you here, because they monitor actually the public presence and the dialogue on these different forms of communication. Finally, you have to call your legislators. Super easy to pick up the phone if you can't travel to Albany. Reach Skelos, Hasty, Lentol, Mazzolio, your own senator and assembly member. And then those of you that can, we encourage you to go to Albany to show your support. And if there are folks that are interested in going, I suggest you contact us. You can reach Stephanie Gendel at my office, and we'll try to figure out how to make sure you know who you should target in those meetings and what kind of support you might need to help that happen. Wear the Raise the Age button all the time. If you need more buttons to give other people, visibility is everything in this game. And then if you want to be more involved in the day-to-day for the next 6 weeks, God willing, this is part of the budget adoption, which is our goal. I encourage you to contact Stephanie Gendel of my office at sgendel@cccnewyork.org because there is really, truly strength in numbers. And it's our view that this legislative session is the right time to make sure that this becomes law and we do better for our young people in New York while also protecting public safety.
Thank you. Okay, we'll begin, we'll start taking questions, but I just wanted to note that it was Stephanie and Jennifer and Denise and Bill Silverman and people in this room who got more family court judges. Legislation passed last year, and this can be done. Bill Silverman always said last year that was the year for more family court judges. I'm sure he says this is the year for raising the age. So it really can be done. This is not a fantasy. We've done it before as a group, and we can do it again. Are there questions? Yes.
I guess this is for Judge Marks, but anyone can answer. What can we as family court judges do? I sit in Rockland County, but I know a lot of judges, family court judges, are interested in making sure this happens.
Well, I think the Statewide Family Court Judges Association could take an active role in this, and we work. OCA works very closely with the judicial associations, and we need to take advantage of the family court judges and use you as a resource because a lot of people have raised the issue of, well, family court is so overburdened, and it's probably is the most difficult court in our system, and the family court judges have the most difficult job of any of the judges, and I mean, how can you now dump more cases on the family court? And we got these new judgeships, but we got the new judgeships because there's been like a tiny number of new family court judgeships over the last 30 years, even though family court filings have literally doubled, over the last 30 years. So, you want to use these new judgeships on these additional cases? Don't you need them for all the other child protective cases and all the, the other things, family? And the answer to that is yes, but I think, as I tried to emphasize, family court can absorb these cases, and we'll do what it takes to make that work. And I think if legislators hear that from family court judges themselves, that
Well, I guess that's my question. In what
Yeah.
way? I mean, should we be speaking to the legislators?
I think that it's important that everyone speak with one voice, so it should be done through the institution of the Family Court Judges Association and working closely with OCA, because I think, as you know, we do a lot of lobbying on a lot of issues in Albany, not just our budget. But I think we could talk about this after, but it's important to speak with one voice. And I think that the court system should be speaking with one voice about this.
Okay, next question. Yes, Maria?
Speak to who will represent the, can you speak to who will represent the defendant in each of these parts? And, you know, I'd like to actually understand if it goes to directly into family court, if it starts at youth court and then gets removed, who's going to be representing the individual?
Well, I would say very unsatisfying answer, which I'll give you. We really didn't address that in the report, so it's going to have to. There are many details that will need to be worked out. That's one of them. I think, but I will be kept honest by my colleagues. But I think the current system would be extended in essence to the new cases, so that if it's treated as a juvenile case and is in family court, it's treated as juvenile cases are now. If it's in criminal court, it would be treated as criminal court cases are now. But the one thing that may be relevant on the other side of the case, DAs, it was kind of an important part of our recommendations that DAs retain control over the case, or at least have the option of retaining control over the case regardless, even if it's transferred to family court. We did not want a situation where it was going to be automatically transferred to the county attorney or the corp counsel just because it was transferred to family court.
Anybody else out there? Yes, ma'am?
I'm wondering where the role of mental health issues, I can speak pretty loudly, where the role of mental health issues and even cognitive disabilities comes in, because I think we know just in general for people who are committing crimes that's true, and where that might have played out either in the report or the direction that the campaign wants to go.
So the one, there will be risk and needs assessments being done. I mean, there's a move in New York City and across the state around this issue, and the role of risk and needs assessments and the role of mental health. Cases runs lots of programs for people who have mental health issues. We run an Article 31 clinic for people who are doing that. So the mayor had a task force on mental health and criminal justice. So I think that this is an issue where there is more and more focus, more and more attention. This reference to brain science that's in the report. I think everybody, I assume training of judges that will go on for judges who are in these youth parts will have a heavy emphasis on that, although as everybody describes the process and procedure here, it's enough to, create a lot of training around that. But there will be a lot of emphasis on that, and I just think this is a time when those issues are being increasingly emphasized throughout the justice system at every possible level. And so that's one of the things that's exciting about this, is that knowing that those issues will be recognized and taken into, I hope, consideration in judges' decisions, but certainly part of a process that people go through.
Judge?
Can I just add one thing on that? We spent actually a fair amount of time with the folks at Bellevue who are taking over the detention for New York City, the mental health treatment in the detention facilities. And if you look at the longer report, I didn't spend much time here on it, but if you look at the full report, there's a pretty detailed discussion of some of the specific evidence-based interventions that are working, Blue Sky and some others that are working very well in New York City. And in many ways, New York City is a model for the rest of the state on this, because the success that New York City has found in diverting cases and adjusting cases, keeping them out of court through those kind of evidence-based interventions is pretty remarkable, and needs to be expanded to other parts of the state. I mean, it's upstate. It's not surprising that when you look at the statistics, the overuse of detention for juveniles and for 16, 17-year-olds is clustered upstate, because the options that they have are very minimal. And I mean, that's partly a financial issue. It's partly a geographic issue. There's not the density. It's much harder to get folks to services physically. But the report spends a lot of time on that issue and some of the services that need to be developed.
If think Judge, okay, go ahead.
You know, Judge Marks and I have been sitting here like commiserating a little bit on that question about the representation, so we just wanted to
Okay, good, sure.
add to that. For those of you who are familiar with family court and criminal court and the transfer of cases that originate the jails and then move down back to family court, it would be very much the same way. You have a public defender who will represent a young person in criminal court. If that case gets transferred, it will get moved to family court, and someone from JRD or another defender in the family court system would provide the representation, and the only question will be the resources to provide adequate representation for those young people. But the system is actually already doing this.
Thanks. I just wanted to follow up on that defense question and Maria's question and with the additional information. So one thing to think about also is that, you know, it works that way in New York City, but maybe not so much upstate, so there might still be some issues that might need to be worked out there. And then also we heard that there would need to be some specialized training for the judges with the new youth parts and those sorts of things. So we're just wondering, and when I say we, I'm from the office of the New York State Office of Indigent Legal Services, so we have some concern about whether or not there might be a need for specialized training also for the attorneys who will be representing the kids either in family court or in criminal court, and whether or not those kinds of issues have been taken into account.
Yeah, look, there's no question. This, as we said, this is not a simple thing. It's complicated logistically, procedurally, in a lot of ways, and everyone is going to need training. But fortunately, the effective date, you know, has been pushed out. So, and will be phased in, you know, over a period of time. So, but there's no question, everybody involved in this will need training.
And I think
Judge Marks, I wonder if OCA has any concrete plans about shifting resources when you see that, say, the activity in the family court grows and perhaps lessens in the criminal court.
We don't, because again, fortunately, if this all happens and the legislature passes the bill and the governor signs it, we'll have time to prepare for it. But at the moment, there's no planning going in, because although we have an estimate of how many cases we think this would involve, that could well change over the next couple of years. So there's been no concrete planning yet, but it would require a lot of planning. And as I said, we'd be able to do that, and we would provide family court with the resources it would need if this were to become law.
Maria?
I was thinking about, Joel, your comment about the programs begin at arraignment. And while I think that's a great idea, what the thought I have is, well, what about the youth who say, I didn't do it, or there was an overcharging, which happens, or something else? And the other thought related to this that occurred to me was, I believe in the current drug treatment courts, you basically have to say, I did it in order to be a participant in the program. And I think it's possible that some of these youth, whether or not they did it, could use a drug treatment program or some job program or something else. So I'm wondering whether you've thought about those issues and how to sort of balance the,
Right.
well, I may actually have a defense and a prosecutor may have overcharged me, or maybe I really didn't do it.
Well, we're not standing, programs like cases are not standing in the way of anybody's defense. And if these programs are taken in on a pre-play basis, yes, you're right, there may be kids who are getting services who have not, at the end of the day, will not be convicted of any crime. I understand that, and that's something for the young person and his attorney to work out. Everybody comes into our program voluntarily, right? There's anybody can say no to coming into the program. I realize the pressure that they're under, that the judge is sort of standing over them to do this, but we are not compelling anybody to come into our programs. We're not interfering with any pleas that are the plea that the young person is taking at any point in the process. And we only come in after conversations with defense attorneys that suggest that this is the appropriate step for their clients. That we very much, well, at the end of the day, I think of a program like cases as ultimately responsible to the judge and independent of prosecutors and defense attorneys. We're also not entering into the mix without defense attorneys telling us that this is the right way to go. So I don't think we're going to be playing a part in undermining that. For the young person who is not going to take a plea to this, we all read that, not we all, but those of you who read that terrible story in the New Yorker by Jennifer Gonnerman about the young man who sat on Rikers for 3 years, who refused to take a plea. And, you know, hopefully we'll avoid those totally tragic situations like that one.
Well, and I guess what I'm saying, I mean, I would hope that the judges who are trying to sort of move cases along with the prosecutors are not going to sort of encourage the plea as some kind of implicit precondition to participation in programs.
You know, we're taking pre-plea cases now, and we have not experienced them.
Okay.
We're trying to take more and more. It's a culture
Good thing,
change.
whether or not they,
Yeah.
it's a good thing either way.
And we're recommending a whole host of services available for young people. Cases is one opportunity, but there'll be many others. Those all kinds of support services that young people could take advantage of, and whether, you know, however their case is resolved.
Yes.
We're going to try to wrap it up, so any last questions? I saw one person back there and maybe one here, and that will be it. Okay? Go ahead.
I just wanted to add, I mean, just as a recommendation that when going back to this pre-plea issue, we've seen the pre-plea diversion take many different stages over the last 20 years, depending on the county and the jurisdiction. Just to recommend that any discussion that's had about this arrangement include both the defense bar as well as the district attorneys associations, because I think that's where the dialogue comes in as to what are the provisions to make this a voluntary entry of a program sometimes in certain court proceedings. So just a recommendation. Thank you.
And one more up here, and we'll wrap it up. And I'm sure some of the panelists may be available after,
And we have extra buttons.
and we can talk to each other before we talk to the outside world.
Thank you all for your work on this. It's really remarkable. I had a question about the politics of it. It seems in some sense like, is it going to be accepted or presented as a package? Are there any pieces of it that you think are more controversial or might be kind of eliminated, and just trying to figure out where, as advocates, we would need to push would be helpful.
I would say we shouldn't trade away anything. We shouldn't like negotiate against ourselves. Our job, well, I would speak from the Raise the Age campaign, our job is to make sure that the package that's been submitted and as part of the budget passes. That's our job.
Okay, just wanted to be clear.
And I think the stronger and more unified we are on that front, the better off we'll all be.
And I would add to that, when we looked at the system, we looked at it as a comprehensive. We took into serious consideration, we could just recommend that we raise the age to 18, and everything else really for young people would fall apart, because the system wasn't constructed in such a way that it would benefit a young person just by raising the age. So I think we should look at this like a sweater where you pull that one thread and it starts to disappear. So we don't want to start to unravel the package. It all really needs to go together if we want to get the kinds of outcomes that will benefit the young people and safety in the community.
I guess maybe let me ask it a different way. I wasn't suggesting that we should advocate for different pieces that are interesting to us, but as we go out and speak to people, are there pieces of this that you feel like there might be more opposition to than others, just to be prepared? Or is it, not having done this work, it's just hard to get resolved.
I mean, I'll tell you what, I'm extremely cynical, so I'll answer that question. Look, the most controversial part of it, or the piece that is most difficult, I think, is the notion of handling 16 to 17-year-olds in family court rather than in criminal court. And, you know, our recommendations try to strike the right balance there so that, you know, there's still, for certain of the most violent cases, they will remain in criminal court. But I think the key part, there are 2 points that to me are most effective to be made in response to that concern. One is that family court is already handling a lot of very serious violent cases, JO cases. I mentioned a third of them are already being transferred. So the family courts have shown capacity to deal with those cases. And second, the recommendations and what's in the governor's Article 7 bills are do strike that balance. That for cases, the most serious violent cases are still going to remain in criminal court, and no one should fear that 16, 17-year-olds, violent 16, 17-year-olds are going to be let out of facilities just because of these reforms. I mean, the most serious cases are still handled in a very serious way, and there's just nothing to fear in that regard. I think politically, there's going to be a concern about where new facilities are placed. Do I get one for my district? And I think that's just the way it works. So hopefully they'll be well placed and people will appropriately placed and there'll be support. I do think that the other thing that I guess I'm also an optimist in some ways in my sense that on this issue. I think we benefit from the fact that it's actually not. It's pretty far down the list of controversial issues that is facing the legislature this year, and hopefully it will actually kind of slip in under the radar. I say that tongue in cheek, but I think that there's more. My sense is that there's more comfort with this than a lot of other things, and that there's a good chance that it all gets passed. But.
So thank you very much.